That's where I want to pick up. So I'm just curious about the federalism implications of this case. Forget about the militia for the moment, okay? Under the spending clause today, the federal government effectively employs or provides the budgets for 30 to 40% of state budgets today, and many, many, many of their employees. Are they now, in other cases, Medicare, Medicaid, the examples that Justice Barrett offered, are they now agents of the federal government effectively? Are they effectively federal agencies?
No, because in that, merely providing federal funding is not the same as providing a designation of federal authority to hire, fire, and supervise employment.
Let's say Congress provides those similar kinds of provisions in those other areas. We allow the states to hire and fire the employees that we are funding, but it has to do whatever we say. You know, you are now a federal agency. I know you thought you were a sovereign state, but it turns out you are in fact a federal agency.
So two responses to that. First of all, I think the hypothetical you just gave wouldn't convert them into federal employees. If they were in fact federal employees, not just federally funded, and then the state was given the authority to hire, fire, and supervise them in their day-to-day federal roles, I think that would look a lot like petitioners here.
Okay, so in other words, there is nothing in this case that's particularly unique. Congress could replicate this same structure with respect to other spending clause programs.
It could replicate it, but it is unique in that this is the only statute, 709D is the only one that either we or petitioners have been able to identify where a state employee supervises, hires, and fires federal employees into a federal role.
Now, I know we don't have a constitutional commandeering type claim here, but is there some concern the government has about converting state militia officers into federal agencies?
So a couple of responses to that. First,
I'm just sure this is something you all have thought about too, so I'm curious.
Absolutely. So I don't think this case in any way implicates militia concerns because, as this court recognized in Babcock, dual status technicians really do have three separate roles. And one of those roles is a federal military role, one is a state military role, and one is a federal civil service role. And that's the role that this case is about. And in fact, dual status technicians are barred by federal statute from collectively bargaining over the conditions of their state and federal military service or active duty training.
And then I'm sorry, just to circle back to, is there any limit you see on Congress's power to replicate this scenario in other spending clause programs at all, or none? I'm just curious.
I don't think, I'm not aware of any limit. I think obviously this is a unique situation, and dual status technicians are, as this court recognized in Babcock, an extremely rare bird. And the role that adjutant generals have is
the government doesn't see any inhibition to Congress's power to turn states into federal agencies for purposes of whatever, whether it's collective bargaining or whatever other good interest it has in mind.
Just two responses to that. First of all, I think there's an important component of this, the state consent. Petitioners have agreed that they have consented to this system, and I think if there wasn't that consent, and if they didn't have the ability to cease hiring and firing dual status technicians, that would be a different situation. But to the extent that there was a consensual role and that Congress actually wanted to make a bunch of state employees federal employees and create state entities to be federal employers of them, I think that would look a lot like this, and I don't see any distinction.
Beyond consent, do you see any other limits?
No, not that I'm aware of right now.
Ms. Reeves, why